Justin Allen.
You're Mr. Allen? Yes, sir. Okay, just a couple of things to make sure you, and you probably already know this from watching, but just make sure you understand. You have a total of 15 minutes to argue your case. If you, and you can use it all 15 to start, and then the appellee will go and they'll have 15 minutes. Or you can reserve a portion of your 15 minutes to rebut or to rebut whatever the appellee says. So have you already, I just want to make sure that you understand the groundwork we're proceeding on here. So we'll hear from you, sir.
Good afternoon, honorable members of the appellate court. Unlike the opposing counsel and has been pointed out in trial court transcript analysis, I am far from a professional public speaker. Therefore, if it pleases the court, I would like to convey my oral argument in the form of a prepared statement.
Do you want to reserve any time?
3 minutes.
3 minutes.
Probably won't take the whole 15.
That's fine. 3 minutes will be fine. So you have 12 minutes now and then 3 minutes in rebuttal. Proceed.
There's not much I care to say that has not already been addressed through previous correspondence with the court. I simply plead that the court fully digest all evidence and testimony presented through trial records and briefs and come to a fair, unbiased ruling. When looking at the full scope of this case, it must be asked, logically, rationally, what makes sense? The idea that this individual who before this trial had no record of sustained unemployment, violent or criminal activity, issues with addiction or substance abuse, who successfully completed a bachelor's of science program from a notable university, was honorably discharged from active duty in the submarine force with 2 Navy Achievement Medals, had a successful career for over a year as a probation officer while being displaced in a homeless shelter by the opposing party, was also somehow leading a double life for 4 years as some raging and fossil violent addict, or the reality that the spouse of this said individual, who has practically no employment history, who, despite alleged horror stories of the brief period of having survived on E3 military pay, had in fact become well accustomed to enjoying the well-supported lifestyle of a stay-at-home parent with full access to the income of their E5 spouse. This same spouse chose the most vulnerable time of their spouse's life when that spouse was trying to readjust to civilian life to enlist the help of their own mother, who is a mother of 6 and spent much of her adult life benefiting from child support, assets, and alimony received from multiple divorces, along with the help of a local attorney with a reputation for winning by any means necessary to contrive this fabricated scenario, obviously aimed at receiving full custody, rights, and permission to relocate. A desired relocation, it should be noted, coincidentally, would take these same children back to the same area, thousands of miles away to that of a previous residence where a new boyfriend has continually resided since before parents moved to Tennessee, and the sudden courage to finally receive help and seek divorce was found. A new boyfriend ready and willing to provide the same supported stay-at-home parent lifestyle, all occurring at a time which that vulnerable spouse no longer had access to support from counseling or family service, or what was described in her own words as teams of vicious Navy lawyers, otherwise known as salaried employees of the government representing the Judge Advocate General, who operate with the integrity of military service members and are not swayed by private practice incomes or affiliations with local bar associations. With all due respect to whatever decision is made here, I will continue to do everything in my power to assure that my children know I refuse to ever give up on them. It has been difficult for me to be vulnerable, not only because I've been repeatedly gaslighted and mocked for allegedly falsely playing victim, but because it is my natural instinct as a defender and provider to push forward and persevere and put those who are dependent upon me before my own needs. But I stand here today prepared to admit nothing pains me more than the thought of my children's fleeting childhood that I've already missed so much of, even when some of it was voluntarily, as I solely took on the responsibility for providing. The past 3 years of my life have been by far the hardest. I've spent countless days and sleepless nights struggling to push what were once happy memories of my children that have now become painful reminders of their absence aside, only to find myself later brought to tears at sights and sounds of toys, games, movies, songs, things that I knew brought them joy. I know in my heart what has been falsely labeled as fear and anxiety in my child is simply similar emotional trauma inflicted by this abusive legal system to alienate us from each other. In closing, I'd like to remind the court of the words of the 18th century Scottish-born colonial American lawyer Andrew Hamilton: "The suppression of evidence ought always to be taken for the strongest evidence." The gravity of this case may not be as monumental as that of the trial of John Zigner, but the core sentiment of Mr. Hamilton's statement still rings true with what transpired over the months spanning those 3 days of trial, stretched over 3 months in the fall of 2020, and all the appeal proceedings since. And with that, I just want to ask the court, do these look like children that are in fear of the parent that they're with? I'll gladly pass them up. These were all taken between the time I was separated from my children and trial in fall of 2020.
Sir, what are you actually asking this court to do?
To revise the ruling, the current ruling given by the trial that basically gives my ex-wife full control of the children. She hasn't allowed me to see them at all. Like I only saw them 3 times last year.
Now, you mentioned about moving with the children to another location. The court had not actually allowed that to happen, though, has the trial court?
No, sir, they haven't, but it was obvious by the testimony at trial that was the desire of my ex-wife. That was what all her testimony was aimed at. And then secondly, with how the court did rule, they ruled with a bunch of unnecessary stipulations that go out against what they had previously ordered, which allowed her to say it's not in writing that I have to let you see the kids, and that's what she's done. She's gone by that technicality to use that verdict to prevent me from seeing my children, and I've submitted the evidence in the trial record as a rebuttal to something opposing counsel has submitted, that I've repeatedly tried to attempt to communicate with the trial court to get them to fix this, and they've basically ignored me.
Anything else right now, Mr. Allen?
One more thing.
Certainly.
I didn't catch it until going over the appeal, but I've mentioned it several times in my brief. There's an MDA that was submitted as evidence that's conveniently only the first half of the MDA. They didn't submit the parenting plan, and I have it here today just to prove that it exists, because like I said, I mentioned it several times.
The parenting plan, the parenting plan that the court adopted?
No, sir. During trial, there was a mediated divorce agreement that was mentioned several times that was signed by all parties except the judge, and it was never signed by the judge because the opposing counsel's lawyer at trial held on to it. And in that MDA that was signed in 2019, there's a parenting plan that would have allowed me to have basically every other weekend within weeks of the signing of that parenting plan in 2019, proving that my ex-wife never saw me as a threat to my children. This is all just out of spite and out of her long-term goal to get the right to move the kids to Washington with her new boyfriend and, you know, teach the kids that I never wanted to be part of their life.
Okay. A couple of things. The one, as I think, as Judge McClarty asked you, the trial judge denied her request to move to Washington, correct?
Yes, sir.
All right. And the second thing is, again, as far as procedurally, with a very, very few exceptions, all we're allowed to do on the appeal is to look at what's already in the record, what was presented to the trial court and what was contained in the record. We don't take here, like we couldn't, like opposing counsel over here couldn't bring in a new witness to testify for us to listen to, and can't present documents or anything to say, here are some new exhibits we'd like. So we'll look at we'll look at everything that's in the record, all of it. in reviewing it, but we can't really review and consider things that were not presented at trial to go through. And there are some exceptions to that, but very, very few. And so that's one of our boundaries of what we're constrained by. Okay. All right. Anything else, sir?
I'll reserve the rest of my time, Your Honor.
That's fine. You have your time for, I'm sorry, are you done for right now?
Yes, sir.
Yes, sir. You have your time for rebuttal after this is here. We'll hear from the appellee.
Good afternoon, Jason Creech of the Washington County Bar here for the Appellee. And I've had this case in my office so long, I went back to look and see just how long it's been. And one of the tragedies of this case that I realized is that Mr. Allen has had this appeal going for 482 days. He filed a notice of appeal December 17th, 2020. We're now 482 days out. And I gotta say, as a pro se litigant, I have never seen anybody who's been more determined, more vigilant, and put more effort into their case than Mr. Allen. However, if he had put that same time, energy, and effort into addressing the problems that got his parenting time limited by the trial court, as opposed to litigating through the courts, he would probably be exercising parenting time with his kids today, as opposed to arguing with me. He was so eager to fight, he filed a premature appeal, as Your Honors noted.
Counsel?
Yes.
We don't need the editorializing in regard to Mr. Allen, so just keep it on the issues and what's...
Well, as I pointed out in the brief, the first part, and I realize he's pro se, but the first procedural element is this court doesn't have jurisdiction to hear this appeal. As I pointed out, because if you look at the memorandum order of the court, which was the last order, the trial court said, Mr. Allen, I want you to finish parent-child interactive training. I want you to have 6 visits with your kids that are supervised. I want to get a report back from the entity called the court clinic, which is the entity that was tasked with supervising his visits. And then I want you to come back March 3rd, 2021, so we can look at your visitation. Again, the tragedy for me is that I don't think the trial court wanted this to be the final word for Mr. Allen. I think the trial court wanted him to take a look in the mirror, address some of the problems that he found were obvious and glaring in the record. And I think the record speaks for itself.
Let me ask you this. As the order stands now, he has no parenting time, correct?
I believe that is the logical extension of the order, because what happened is there's nowhere in the record that they came back on March 3rd. There's no court order that follows up on what was supposed to be a stop along the journey, not the end of the journey. And so what happened is...
So he really didn't make a ruling at all on his parenting time. He said, go to the PCIT classes, do your visits, get your report, come back, and then I will decide what your parenting time is?
I believe that was the intent.
Because my concern is now, I mean, as it sits now, he has no parenting time. I mean, it's basically like a TPR, but without having done a TPR.
It is a problem because the court never intended for this point in time that we are now to be the case. You can
So do we need to remand it back then for those steps to be completed? Because there is, I mean, your argument is we have no jurisdiction.
That's correct.
So the proper thing would then be to remand it back for completion of those steps and further orders from the trial court.
I believe that's also correct.
Okay.
And again, I think the problem here is that, and the court pointed this out in its finding, and that is Mr. Allen has chosen to create an enemy to fight as opposed to perhaps look inward. And so if you look at his brief, there's a lot of victim narrative that goes on. You heard him even today somewhat disparage the maternal grandmother, say he's been gaslighted, it's an abusive legal system, and he disparaged my client's trial court attorney, who I would have to say referred me this appeal, so I feel sort of duty-bound to remind this court that she's a very good and ethical attorney, and the record speaks for itself. And he goes through, again, a victim narrative as to why he believes this order was the way it is. And the first thing that I would say is that the court went to the statutory factors, did everything we want a trial court to do, looked at 36-6-106, heard from all the witnesses, took the facts presented, the evidence, the exhibits, matched them to the statutory factors, and far from bias and an abusive legal system, the court was convinced that father was psychologically and physically abusive to both the children and to mother, that he has anger management issues, unaddressed substance abuse issues. He was very concerned about the counselors testifying as to the physical ramifications of stress in the minor child, such that she was having panic attacks about being around the father. All of the proof was uniform. Whatever I say or Mr. Allen says about why, all the proof was uniform that the relationship between father and children was fractured in such a way that it was not appropriate to just say, here's a 50-50 parenting plan, have a good day. Most telling to me is page 4 of the memorandum of opinion, where the court says, father did not exhibit or relate to the court any sense of wrongdoing on his part, or that he may have physically hurt their daughter. In fact, this is the real driver for me, where the trial court says, Mr. Allen's refusal to admit to possible fault on his part will be a major hurdle in regaining his daughter's trust. And it's this refusal to admit possible fault, which is why he has fought so hard, in my opinion. That is, I think the trial court was spot on, because his brief overlooks and disregards all the findings that are the subject of testimony, of exhibits, of the counselor that he called and the child's counselor. All the findings of the court he just disregards to get to the proverbial entity. I don't want to just recite my brief, but there's numerous incidents of abuse that the court was very concerned about that I put forward in my brief. In fact, if you read the transcript as closely as I have, you'll notice there's several times where the trial court will stop and say, now wait a minute, what day was that? And make sure he heard certain items correctly, because those items came back around in his memorandum of opinion as being very, very important. Both counselors, again, regardless of how you classify it, both counselors thought this child was not coached and was either extremely angry at the father or anxious to be around the father, but for whatever reason, there was a problem. Mr. Allen disregarded the testimony of the maternal grandmother, who apparently he doesn't care for very much, and the witness, whose name was Gabriella Lorenzo, who testified she firsthand observed these visits. She was an observer to these visits and told the trial court there's a lack of affection, there's some awkwardness, it's uncomfortable. She observed the nervousness of the child. She saw the parenting time in real time. And again, instead of fixing the problems, what Mr. Allen does is he files his brief, very first point out of the box, the trial court was biased against me because of my satanic views. And again, to his credit, he found Rule 610 of the Rules of Evidence. I frankly it's never come up in any trial I've ever had, and so I was kind of taken aback by Mr. Allen's resourcefulness with the Rules of Evidence. I thought, that's an interesting point. Of course, I looked at it, and it's not applicable, because if you look at the rule, it says that opinions or a person's religious beliefs can't be used to raise or lower their credibility as a witness in a vacuum, which of course makes sense. The rule does not say it can never be discussed. And Mr. Allen's position puts us in a curious light as family law litigators, because the parenting plan form issued by the Tennessee Administrative Office of the Courts has religious upbringing as an element of major decision making. People don't often argue about it, but if it's something to be disagreed upon, the trial court has to hear some proof about religious upbringing. So the next problem with this sort of conspiracy theory of sorts, is that the trial court does not mention Mr. Allen's religious views at any point in his ruling on custody or, frankly, the credibility of the witnesses. In fact, the trial court found Miss Allen more credible based on the testimony, his firsthand observation of the parties. For example, the trial court noted Miss Allen's very emotive quality, how she was tearful and how she presented, and he found that Mr. Allen simply had no room in his mind for the possibility that he could have done something remotely wrong or that needs redress. And the trial court found that all the exhibits introduced corroborated mother's position. So his statement that his satanic views had some import is, I think it's a little bit of a red herring here, and it's easy to claim a conspiracy theory, but it's really hard when all of the proof falls on the other side. He goes to some very odd places in his brief, so far to say that Miss Allen went to a domestic abuse shelter with the children to, quote, strengthen her case by studying and mimicking the behaviors and stories of actual abuse victims. I assume he's accusing Miss Allen of being some kind of method actor. He accuses Miss Allen and her counsel, Miss Page, of taking strategic restroom breaks to somehow affect the outcome. And he says that, page 18 of his brief, that the evidence my client obtained and used, it somehow shows her to be vengeful or wanting revenge, or as a violation of privacy, and it was abusive to him. In fact, at one point he says he was actually the victim here, which is, if there's any gaslighting going on, I would submit that is it.
Can I interrupt you and go back a minute to kind of where we are procedurally, looking at the addendum to the parenting plan? So we know that he got 0 days of custody under the trial court's findings. And then with respect to visitation, the trial court said you need to go through PCIT and those things we've already talked about. But then in the middle of the order, it says, until the clinic begins its supervision and observation, father shall be entitled to the following visits during the upcoming holiday season. And he gives the father November 28th, December 12th, and Saturday, December 26th. I read that as saying that he's entitled to that before we do the PCIT and do all of that. What happened with that, if anything?
The record is silent as to that.
Okay.
And I would note to the court, one of the faults I have is that I started with the transcript first when I did this appeal. So I started the statement of facts, and I started working on the substance of the brief, and then I got to the technical record last. That was a fault on my part, because as I went to the technical record, I realized this order is not a final order, because there are things that the court is to do. I filed a motion with this court to dismiss the appeal, to send it back to the trial court to fix it. This court told me in so many words, let's finish up the briefing and have the oral argument, and then we'll make a decision on that. So when I found out that that memorandum order has the same problems that Your Honor is testifying to, I tried to file a motion so that it could be addressed, because I'd like to think I'm smart enough to know down the road this is going to be a major procedural problem. But again, the court said you'd rather hear the full matter before making a decision on that. But I admit it's a problem, because it's a dead end. If nobody goes back to court on that hearing date that the trial court suggested, it's a dead end road. I agree.
Well, it just leaves the custody determination as it is, and then there's no visitation.
That's correct.
Because the steps weren't taken.
That is absolutely correct.
All right.
Let me ask you on that jurisdiction question. Can a trial court kind of retain jurisdiction and prevent an appeal by saying, here's my ruling now, but we're going to look at things 6 months from now, and I'll decide then what to do?
I don't think so. I look at jurisdiction like a baton. The court has it until someone files a notice of appeal with a final order, and it's handed to the Court of Appeals. What I think would be appropriate procedure in that case is for someone to file an interlocutory appeal or an extraordinary appeal to this court and say, what the trial court's doing right now short of entering its final order, is in error. And we have rules in our rule book to address the very scenario that Your Honor says, where if the trial court is ruling 99% but holding 1% back just to prevent the entry of a final order, I don't think that's good procedure on the trial court's part, but we have rules to address that. It would just need to be under Rule 9 or Rule 10 and not an appeal of a final order. And I think that's the fatal flaw here. And obviously, I think the record is littered with pro se cases where they made mistakes not knowing what they don't know. And unfortunately for Mr. Allen, I don't think he didn't know what he didn't know. And that is that there has to be a final order for leaving nothing for the trial court to do for there to be an appeal under Rule 3. And if there is things for the court to do, there's a different procedure which he didn't do. And I'm very sorry that's the case, but I believe that is the case, Your Honor. And that's my time.
You've used your time. Mr. Allen, you have your time for rebuttal now.
Your Honor, so Mr. Creech, he said a lot of things. I don't even know where to begin addressing all of them.
Down, let me ask you, move that microphone a little bit over more in front of you, so be sure we can hear you. Thank you.
Let me ask you this. You know, the trial court's order basically said that your ex-wife gets full custody of the children, but he left open you to have the opportunity for visitation. What happened with respect to those visitation days? Is that information contained in the record?
In the appeal record, yes, there's some of it.
Okay.
In the trial record, there's not much there because there's nothing beyond the last day of trial. But in the appeal record, in rebuttal to Mr. Creech's motion to dismiss on the grounds of jurisdiction, I believe there's more than enough evidence to prove that the trial court has completely given up on any claim to jurisdiction.
Are you appealing the trial court's decision to give your ex-wife full custody, or are you appealing the trial court's decision on your visitation, or are you appealing both?
It's a combination of both.
Okay.
It's the decision to limit my custody based on all these, the PCIT and all these things. These, in my opinion, these were intentional stipulations just to stretch out her time in full custody, because the longer she has full custody, the more my daughter develops all these symptoms of fear and anxiety, despite the fact she hasn't even seen me during that time, which strengthens her case later on that the relationship is so fractured that I should just give up my rights. Mr. Creech, and like I said, I hate saying that, I know it sounds bad, it furthers his story that he's trying to tell that I'm just making all this up. But for example, he states that, you know, it's crazy for me to say that Hayley just went to the shelter to strengthen her case, but I got that idea because during a visitation, the children told me that during that time period, they frequently traveled to their Nana's house. So did they really need to be in the shelter, or could they have just stayed at their Nana's house that whole time? And just reiterating the point I want to get across, the suppression of evidence ought to always be taken as the strongest evidence. He's talked about all this evidence that was presented in trial. What's not mentioned is the things that are mentioned here and there in trial that were intentionally pushed to the side. You know, Ms. Lozano did a few visitations. There was substantially more visitations supervised by DCS than there was Ms. Lozano, but before trial ever occurred, Ms. Page filed a motion to squash any testimony from those DCS investigators. Once again, the suppression of evidence ought to always be taken as the strongest evidence. Why would she do that? The same goes for the testimony of expert opinions. Mr. Creech is trying to sell this idea that both the expert witnesses were supporting their case. If that were so, why was the first expert witness continually objected to by Ms. Page? I guess that's my time.
It is, Mr. Allen. Court's thanks to both sides. Mr. Allen, again, just to make sure you understand the procedure, and you may already know what happens next, but we'll take the case under advisement. We'll arrive at a decision, and then there'll be a written opinion, and that opinion will be sent to you and to counsel at the same time. All right, thank you. Thank you both.